The first question is, I just found out that Amex filed a lawsuit against me for $93,000. I haven't been served yet. What should I do? If you remember a couple of weeks ago, or 2 months ago, maybe, I did a video how to fight a collection lawsuit, and I talked about garbage time. That's the time when they filed a lawsuit and they served the lawsuit. That can be up to 2 months. That video has all the documents, all the instructions, what to do in what's called garbage time once you find out a lawsuit's been filed against you but not served. Second question is, I'm on disability of a long sickness. Now the IRS has taken 2 months for my disability check. What can I do? Disability is protected from collections, garnishments, execution, on judgments. Only the IRS, unfortunately. Trump just signed, President Trump just signed a thing saying he can even take parts of student loans from people's disability. That's a new change with this administration. Normally how it occurs is there's an administrative garnishment. You get a thing in the mail that says, we're going to administratively garnish you. Normally in America, you can't garnish anybody's wages without a judgment. The exception being student loans and IRS type things, but they send you notice of an appeals mechanism before they do it. So if you received it and you have time, great, but it's probable that what they're doing is legal. I responded to a debt collection lawsuit with a motion to dismiss. Does the plaintiff have to respond to the motion? Of course. Will it? Likely. If it doesn't, you win. So make sure you set a hearing date and look up your rules in your state. So for example, in Michigan, you've got to give someone at least 28-day notice from the filing to the hearing. So make sure you file your hearing date enough time to give them notice. If they don't show up, you win. Make sure your motion to dismiss also says, alternatively, I want the document, more definite statement, because on an early litigation, you're likely to lose, but the judge always wants to be Solomon about it and cut the baby in half, and he'll give an order that says, you got to send him or her the documents, and usually you got 14 days. And if they don't send it in 14 days, you win. You just apply for a default, especially on a court order. How to structure your interrogatories to send to debt collector. I got tons of them, both on my website at killdebt.com, but Parker GPT, it does it all. Just say, I need interrogatories against UHG based on lack of assignment. Can I sue debt collectors that have default judgments against me on the basis that the judgment is void? I believe it's void because of lack of service and fraud. So no, generally, you cannot go to federal court to overturn a state judgment. There's what's called the Supremacy Clause of the U.S. Constitution, and I believe the 14th Amendment, that allows states. And that's the big battle that is currently going on, has been going on for about 40 years now, is what are state rights? Just for example, the abortion rule, the defense of Roe versus Wade, the forces that wanted to overturn Roe versus Wade said, this is a state issue. And now that's been overturned, that's exactly what happened. It went to the states. So half of the states say abortion is fine and half of the states say no, it isn't. So that is an example of states' rights versus federal rights. And so you cannot go into federal court and go overturn that judgment in state court. I think this thing is a thing called a Rooker-Feldman doctrine. Look it up. It gets weaker and weaker. But you can sue the debt collector that gave you the default if they broke the law doing it. You can't sue generally the company that got the judgment against you. You can only do a motion to set aside in the state court action, not the federal. If you win, great. Now you can add another defendant in your federal claim. I hope that makes sense. Wells Fargo sent me a letter saying the full amount of the credit card balance is due in full and said they will turn it over to their attorneys. I want to be able to not go to court, so I need to reply if they serve me. Sometimes it's better that they sue you. I'm not recommending it, because dealing with a headset Harriet pre-litigation, you're not going to get a good deal. Whereas if lawyers are involved, you'll likely get a better deal once you answer. Your hand becomes stronger once you answer against the lawsuit. They know they're not going to get that default. 9 out of 10 lawsuits are defaulted, up to 9 out of 10 in the nation, by people just sticking their head in the sand. Don't be that statistic. So I'm not saying wait for a lawsuit if you can work it out, but Headset Harriet's not going to give you the deal that the law firm is. I could be wrong about that. You can reach out, and I've got videos on how to set a debt pre-litigation. That may be the video to go check out. Believe it or not, Parker GPT will take that video, take all the forms and documents I suggested you use, and spit out how to settle a case for you. Capital One is suing me on alleged discovered debt. Oh, that's beautiful. As I was talking to someone today about that, with Capital One claiming to own, I've got the dog here. Honey, you gotta go. You're doing this all day. Go out. No. Capital One is claiming that they own discovered debt as of May 18th, 2025. And they attach a letter when they change a discovered debt to Cap One. And it talks about the companies merging. But even that letter says, but unless something else happens, then there isn't a certification of the merger. But that's the only thing they attach as proof that there is a merger. So there's no proof. So think about this. Discover takes your debt, puts it in a trust, you default, the servicer is now Discover, and it sues, even though I don't believe it has the right to, not without proof of the assignment or the servicing rights. Now Cap One comes in during the case. That's an extra level that you can just go, Your Honor, where's the assignment of my debt? There's no proof there's an merger. Like to see everything. So yeah, file a motion to dismiss. Make them bring out the proof, which they don't have at this point. Now they've got 14 days if you file it with a motion with alternate service. Now they got 14 days to come up with enormously impossible proof that your debt of billions was transferred over to Cap One. That case will get settled with a motion to dismiss, quite possibly. How do I get collection accounts removed when it is listed as disputed? That doesn't mean it gets removed. However, depending on the stage of the dispute, so you got a debt that you don't think is yours or is incorrect, you file a dispute. They've got 30 days to repair. In that 30 days, if that collection account was dragging you down, your scores down, while it's in dispute and being investigated, it can't have an impact on your credit score. So technically, your credit score goes up. Go get some credit if that's the way you want to go. Be right about your dispute. And under Johnson versus MBNA, I think it's a Fourth Circuit court. That's the Rocket Docket. That's where a lot of Supreme Court judges come from. Virginia. That says failure to properly investigate is a violation of the FCRA. So make sure you're right. Make sure you have lots of documents. I've got plenty of videos on how to properly dispute. If a borrower debtor, this is my last one, filed bankruptcy in an adversarial claim, where in issues as where respetila assignments are raised. I don't really care about what issues are, but if the borrower debtor filed bankruptcy, is that court with authority to rule on those violations, or would separate actions need to be taken? All right. So the actual question is, can I file an FDCPA claim post discharge of bankruptcy? No, generally, because there's a case called Walls out of the Ninth Circuit, I think, federal, says that you must go back to the bankruptcy court and seek to have the creditor violated for doing bad things, as opposed to having a separate action where you go get some money and damages. As I talk in my new video dropping tomorrow, this will be explained. This is just coincidence, but this question is if you can use violations of a bankruptcy discharge under the FDCPA will be explained tomorrow on my new video. So check that out. I want to answer your questions, but it's important that I advise you. It's important that you know how hard I work for you. I've got a great website that before the AI came along was really good. Then the Parker GPT came along. It got magnificent, but it shifted. Everybody's signing up for Parker GPT. Everything I've been doing is now embedded, and it's quicker for you. You can answer a lawsuit, answer a motion, file a lawsuit, whatever. Check everything before you file it. I've gone one step further now. I've hired a company that creates an enormous database. Let me get this right. And will provide you a free legal research of millions of federal and state court legal opinions, judicial decisions, and even the oral recording. So if you want to see how a case is argued, I'll have it for you with this company. This company, if you've heard of LexisNexis or Westlaw, those are huge research firms that law firms hire at great expense to get what I'm going to give you for free. And Court Listener is the name of the company. It's a nonprofit free law project that is going to give you all of that. I'm paying for the service because I've made it so I can embed it and use some of their stuff. But I'm going to put a link on there so you can do legal research, you attorneys, anybody. And it's going to be in Parker GPT is the point I'm making. So very quickly, and then I'll get to your questions. When you go on ChatGPT or Claude or any of that, they're great, but for one thing, they are on acid, meaning they have hallucinations. So it is commonly done where you go, hey, can you do a brief for me? You go, oh, this will be easy. And it comes out, Parker v. Smith. What a great case. It doesn't exist. It makes up cases. When I say it makes, ChatGPT, Claude, all those, they're all hallucinations. And my son, who's in the business, I'll say that, explained why that is, and it makes sense. But Parker GPT, thanks to that same son, by the way, on his own, in his living room, came up with an idea, and he found this great company, a nonprofit, to provide everything I need to do to put into Parker GPT. So I almost can say to you, I'm better than ChatGPT and Claude and all those in the lane that I'm in the lane that you've invested in the debt defense lane. I will have real cases and hopefully no hallucinations. This company actually has a software to eliminate hallucinations, and you're not going to pay for it. It's the price of my membership will stay the same, even though I am incurring a little bit of expense to give this to you. I hope you understand where I'm coming from. In the vein of this free law project by this non-profit, I'm honoring the enormous work that they're doing, not trying to make money or get big profits. It's a non-profit. I'm going to honor that and pass it on to you, and I will not charge you more for something that's going to, what did the young kids used to say, Ting? It's going to be off the hook. It's going to be too cool for school, whatever. It's going to be a dynamite thing. So again, I bought millions of up-to-date Supreme Court cases, federal Supreme Court cases, state court, everyone. There's 470 jurisdictions and millions of cases. Will hopefully by the end of the month be embedded for you in the Parker GPT. So it is going to get, the G will stand for great Parker training. I will get to your questions now. We're going to speed along. Let me apologize for the technical difficulties. I screwed up and pressed some buttons I shouldn't have because I got so eager. I saw people were joining early. So I pressed and I was told I did a bad thing. So we tried to come around. So we just renewed it and started at 5:20. So here we go. Let's begin. Hey, Bad Badger. I like Bad Badger. He comments when I go live. By the way, I do live every day. I try to do about 8:30 to 4:30, depending what kind of day I'm having. So you'll see me changing my socks, talking to a client, putting my hands through my hair, falling asleep, picking my nose, whatever it is. And while I'm doing that, you can make a comment. Don't inundate me. And if you see I'm working, kind of leave me alone. But I'm there for you on free times. I always like to be accessible. So Mr. Bad Badger, troll account number 172, is a frequent flyer, and he seems to be doing well. So is Eva Tompkins. I talk to her a lot. I have just met Dr. B. I like that. I have 2 suits filed in Orange County. Hey, that's where I am. I'm just north of Orange County today. And I'm going back to Michigan. And it's never been served. I relocated to Brevard, but made no attempt to avoid service. 1 suit by Capone was filed in September with no service. So what I'm hearing is garbage time again. You haven't been served yet. It's been filed against is another issue. Use that time. Go to my video. What was it called? How to Fight Lawsuit, about 2 months ago. It's got me in a red shirt going like this or something. And that's a beautiful thing you can use. It'll tell you what to do during garbage time. In the video, I call it problem parker time. So the other issue of that is if you did not live or reside in Orange County, but it was filed there, you can't just move out of Orange County and then go, hey. But if you did not live in Orange County and your state ID says that, and you said Brevard County, they've sued you in the wrong district. And if you did not sign the contract in Orange County, you have a violation against them under 1692I. And I say those 2 things because 1692I says you can't sue someone in the wrong district, and unless, of course, a contract was signed in that district. People don't even, that's just something I read, and it's never, once in a while you read something and go, oh, I missed that. Well, just remember, if those 2 things are the case in Orange County, you have a lawsuit against them, and you can use it as a chip. So if they say you owe $5,000, talk to the attorney as though he is Cap One because he is an agent, and say, I'll pay you $1,000. You owe me $1,000 for suing me in the wrong district. And by the way, if you're in Florida, you're entitled to another $1,000 from the FCCPA. That Florida Consumer Protection Act is more powerful than the FDCPA. So there's some good stuff. The other one, Hayes, LVNV, great. Same thing applies. LVNV is a garbage. So garbage time for a garbage creditor, garbage buyer. The Rooker-Feldman Doctrine. Hey, I didn't catch that case of Doctrine he mentioned. Yeah, that's the Rooker-Feldman Doctrine. Used to be really strong. It's about stopping people from overturning federal state judgments by federal, because that's a supremacy clause, 14th Amendment issue, state rights versus federal rights. You probably can't tell, but if you watch closely, our federal government will eventually disappear, except for the war powers and doing other stuff. All the money will eventually funnel down to the states. The states know that, federal knows that, and you're just watching the beginning of that. And I know it's going to sound crazy. I think AI, which is knocking down boundaries anyway, states, there's no geography. If you have a geography name in a business, like let's say Florida Writing and Research, you just lost a lot of business. It should be Bob's Writing and Research. There's no more borders anymore with AI and the internet. And I say that because states are recognizing that. I think Oregon or Washington did, And now you don't have to be passing the bar to get in court in some instances. But that's the beginning of borders being erased, of states being erased, of federal. The federal court system is beautiful. It's the only thing that's keeping our democracy intact, and that's on shaky ground. But maybe it has to be so far. I'm not a fan of either camp. They're all the same. I used to be married to a politician, so I had to hang out with both blue and red. They're all the same. And the less of them and the more of us is the way to go, I think. So, Michelob Mendez, whatever it is, I feel like a Michelob now. Capital One tried to serve me in my childhood residence that I do not live at any longer. See what I just said about being able to sue them under 1692I and proof of state ID that you never lived there. The further away from it, the better. Get envelopes showing that you filed, that you live in a certain place, get lease agreements, all that stuff. And you can sue them in federal court or make it a counterclaim or third-party claim, going after the lawyers. You're in great shape. It's a good chip. Is a bill of sale that's totally redacted legal? It's all legal. It's not evidentiary coming in. It's hearsay. So if you have a bill of sale that stuff's redacted and they say, well, you owe us because we own it, what is that spot? I want to see that. And by the way, it's redacted because what it really is, it tells you how much they paid for the debts and how many debts. That's usually what that big blob is. They don't want you to know that, along with what's in that bill of sale, which is the forward flow agreement, the purchase agreement. They don't want you to have that. So you could settle that case quickly by going for that. You're legally, rightfully allowed in discovery. If you have a bill of sale or assignment that says, pursuant to the terms and conditions of the forward flow purchase agreement, that bill of sale doesn't exist. In other words, without that forward flow agreement, ask for that in discovery. Case will get settled. Trust me. Well, trust me, but pretty good chance. Totally redacted. So redacted, no, it may be legal, but it's not evidentially credible, reliable, admissible, because it's not obvious. What if you produce a bill of sale that says you own it with a big redacted thing? Just trust me on this. It's not evidentially coming in. And also to pass, if it needs to come in through the 8036 business record exception, you got to see that for that thing to apply. So yeah, just touch that nerve. It's like to a debt collector, debt buyer, seeking the forward flow agreement or looking behind that redacted part, it's all the money they spend, is like taking one of those dental scrapers and put it into a raw nerve of an exposed nerve in a tooth. That's how badly they do not want you touching that area. Capiche? So, anyone have any luck getting a complaint desist due to Discover Cap? That's a good question. It's early days. Supposedly, it only occurred May 18th, and I'm seeing cases now where I'm being sued. My client's being sued by Discover. Suddenly, and now Cap 1 is there. That blow those away. I get those cases settled. So will you. Because it's all about assignment. I mean, think about the layers of assignments and proof going back to hearsay. That letter that's attached to all those cases now is BS. And it's not a proof of assignment in your state. Look, what does an assignment define assignment? And that will not be what that letter is, which, by the way, is hearsay also. So in small claims, there's a discovery process. Depends. If you're in Florida, the small claims is just where cases less than $8,000 go. They have all the rights of evidence and court rules. It's just, that's what they call the small claims court. Whereas if you're in Michigan, their small claims court, which also allows paralegals to come in and do stuff, that's very limited rules of discovery and all that. It's just a place to go settle cases. So it depends on the state. Hi there, Brian Eva. Hello again. It's always good talking, dude. Just Me Doctor's back again. The LV and Vinny has a set hearing date in a couple of weeks, even though I haven't been served. If you're in Florida, that's kind of how Florida does it. What it does, going back to small claims, that means your case is probably less than $8,000. They have you do a cattle call. They say, hey, you got to go to this pretrial, and you get there. I did one a couple of days ago in Duval County. Holy cow. It was awful. There was just hundreds of people. Nobody knew. The judge was almost sitting in this like fake makeup of a place, of a bench in the crowd, and no one knew what was going on. My client was representing an attorney, and I'm used to just busting through. Not that I'm a jerk, but I'm not going to sit there and have this person or this person or this person determine my client sitting there for hours. So I just busted to the judge. I talked the language and I got out of there. It's not something you want to be in. Back to your question. For example, in Florida, where you're at, it's just a way to get the case settled. If you haven't been served, I don't believe you can be defaulted. You might want to not take chances on a debt collector that will default you anyway, and answer the lawsuit, and then go in, participate, and they're going to say, are you settling it? Yes or no? And you're going to say, if it's no, in this case, I'm telling you, there was one attorney, and I saw this description from a commenter today. There was one attorney for hundreds of cases. He's going, do you want to settle? Blah, 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 blah. I want to use obscenities, but it's a nightmare. So if you answer, you're going to be involved in that nightmare. If legitimately you were never served, and there's no way if they served you in your old residence, you got to go. You got to answer, but you put in, I am entering only for the purpose of not being defaulted, and I do not waive my rights to object to jurisdiction and bad service. And then I've got videos on this. Again, Parker GPT would explain it better. Not better, sounds like a robot, but you want to have evidence showing I lived in Brevard County for 2 years. And you also may want to contact the attorney before the cattle call and go, look, I'm happy to meet you there, but you screwed up. And now you owe me if you filed me I've got 1692I. I got to move on. In Illinois, wait a second. Goddess of Destiny. Wow. The whole thing is redacted. In an online credit agreement, should there be some type of acknowledgement to prove I accepted the terms on an online? There usually is. If you're talking about a fintech loan or a personal loan, there usually is. And I've gotten into fights about, is an electronic signing, like a lot of your student loans just have numbers. A lot of times in the older cases, the software wasn't good, so it just was empty, and they'll ask you to sign it, and it's very good area, breeding ground for you to get your proof showing you don't own the debt. TikTok, what about I guess we're live streaming with TikTok. What about if they never serve you, but they sue anyway and freeze my bank account? So that's not what you're saying. What happened is you never got served, and that's that scenario I just talked about. Debt collectors will do this. They'll go tell the court, yeah, I served him. I swear under oath. I did an Amex video a couple of months ago on that specific, where they described my client as 5 foot, 200 pounds, a brown-skinned Indian lady. And my client, who agreed to let me put her picture in the video, is 5'8", frankly, looks like a model, brown hair, white skin. She looked like a model. She's not 5 foot. And they wrote on a sworn affidavit that that's what my client was, and they had properly served her. That's fun. So to make it fun for you, go to the court docket in your case and find the proof of service If you know you weren't served, a lot of times the server will go. In fact, I think Florida, it's mandatory almost. Every one I've done where I've got it set aside because they served the wrong person, it says, person is white, 240 pounds, wears glasses, looks like a pig. I only say that because there's a great Jerry Seinfeld case where George's car gets flattened and Kramer believes there's a pig man in the hospital. But they'll say a description, and I just did one in Florida where my client was a tall, very long-haired, very thin person. They said he was over 200 pounds, bald, and 60. My client was 35. But that's written in the record that you can go pull that out and make great hay with that and sue them. This stuff goes on. When I was a young man, I worked in college, and I was a store detective. So they put me in a vent, and I'd have to watch people, and they would steal stuff. I couldn't believe it. And my eyes didn't believe it, but my heart did, because it would go a million miles an hour. So I'd have to get out of this dusty vent and go chase these people. And they were usually very well-clothed, older people that didn't need to do it. There was a thrill of it. There wasn't like somebody that needed the food or whatever. And this was a drugstore. So I still can't believe my eyes when that stuff happens. But it does. It's all about money. Where there's money, there's issues. So blah, blah, blah. But if they didn't serve you, and now that you need to file. So in Michigan example, back to what about if they never serve me, but they sue anyway and freeze my bank account? In Michigan, for example, the minute you find the garnishment is against you or your bank account or your paycheck, you have a right in Michigan. And I say it's Michigan as an example, so all states are like this, or similar days. You got 14 days to object. If you object on time and file an objection with the court and with the person that's the employer or the bank, by the way, the bank doesn't like this because they just want to give your money away, because they are subject to liability if they don't do it right. So even your employer is. So if you get that objection in on time, that money stays where it is. You get a hearing, and now you can show the judge, I didn't live there. They got this garnishment. Now I've got my money in hold. And the bank or the employer can't send your money to the law firm, and it wants to. And if it does, after it gets, make sure you serve the objection and that hearing date on the bank or the employer or whoever it is. And if they do anything untoward, is the great word, or send the money to the law firm anyway, you got a lawsuit against them. You got a lawsuit. So if, as you say, you can show that you didn't live in that, or, for example, go to court and pull that proof of service that you were served. I didn't live there. I'm not 200 pounds and 5 foot tall. Judges get real pissed about that because they're swearing under oath to the judge that everything is true. That's why you didn't show up, because you blew them up. So can I file a motion to dismiss post answer on the good question? All right. Look at your court rules. But a motion to dismiss or a motion for summary judgment could be filed anytime. In Florida, you do it early. I've done it after I filed the answer because I just got pissed that I didn't belong in this case. It depends on your court, but I don't see why not. You're trying to save the court money and yourself time and money. So if your rules don't forbid it, you should do it. Specific to me or my account, they also claim to have acquired the loan, not that. Okay. Can I file a motion? Yes. Okay. Yeah. Bring it out. Even if you lose, do one. Again, motion dismiss. Alternatively, better statement of proof. You put the burden on them. And if you do that motion early, it comes out early that they don't have the stuff. And they're not required to bring 100% when they file the lawsuit. I teach people, because they haven't, go in hard on that, showing the court they don't have anything. They wait generally till months later when they file that motion to dismiss to say, we own it, there's no material issue here. Bring that out now. Even if you lose the motion to dismiss, the court will at least side with you and go, yeah, you should give him the documents, which I get mad about, because if they need to give me documents, then clearly they didn't have the cases. Rule for my motion to dismiss. But I digress. They didn't have the proof. But yes, and do alternatively, because the judge doesn't want to give you the dismissal, but he wants to give you something because he's Solomon. Remember the Solomon rule? Most mediators and arbitrators follow the Solomon rule. Back in the old days, a lady, let's just say lady lost her kid. Somebody else picked it up. And the lady that was the real mother wanted her kid back. And the lady said, that's not your kid, it's mine. So they went to King Solomon. I'm butchering this. And said, hey, man, that's my kid. And the lady who didn't have the kid and was lying said, no, that's my kid. So Solomon said, okay, this is what we're going to do. We're going to cut the baby in half. We're going to let the mother have half of the baby and the fake mother, he didn't say fake, half of the baby. So the real mother cried out and said, no, she can have the whole kid. And Solomon said, you're the mother. And that's what mediators do. They're too afraid to go one side or the other. So they cut. So let's say you legitimately want $100. If you're in arbitration or mediation, whatever it is, and you've got all the proof, everything shows you deserve 100, mediator give you 60. Because they cut the baby in half. They want to pretend like they're doing a job and they were debating it. Here's something for you, and everybody's going to go away happy or unhappy jointly. So you don't want that. What the hell was I talking about? So look for courts. When you file a motion to dismiss, I think of King Solomon, and I add the motion, also motion for alternate, more definite statement. They haven't provided proper documents. So the King Solomon judge doesn't want to rule one side or the other. Goes, okay, I'm not going to give you a motion to dismiss, but I'll make them give you the docs. Well, it's cool because most court rules say, I looked at Ohio today, says you got 14 days to give this guy his docs or face a dismissal. So it's kind of a backward way of both getting them to show what they don't have and to maybe stopping the motion to dismiss 6 months later from them because they never produced the stuff in the first place. Anyway, Harmony B, judge denied motion to dismiss. Lived in Wisconsin. I was being discharged from 6-day stay in ICU in Wisconsin. Day my son on the spectrum was served on my behalf. In California, opposing, admitted no signed contract. I think you got great. None of those facts are necessary. If you live in Wisconsin and served in California, if the case is in Wisconsin, I don't see why you don't win that on many levels. If the case is in California, I don't think you're served. And then if you bring out the disability of your son, depending on his level of debilitation, you've got a great motion to set aside any judgment or to sue them for improper service and any violation of FDCPA. Ma Jones, so LVNV claimed to have purchased from Resurgent Acquisitions, but my debt validation from the original creditor said Resurgent. Capital Services, can this be used in court? Absolutely. I just argued that same case with a SoFi case. Wish I could attach it for you right here. But a great motion I did. And it turned out that during the motion, the judge found a fifth party, I didn't even see it, that showed before Resurgent Capital got it, somebody else bought it and gave it to somebody else. Those cases are great because they never have the proof. I would advise you, if you have a transfer and assignment document in your LVNV cases, look at a gentleman, Jackson Walker is signing off on those things. Then go online and find his same signature and see if it's on exactly the same as yours, even though it's a different date, different company. That can't be. That's a weird smell test. But their documents are so, depending on the state, easy to overturn as far as the chain of title. LVNV funding cases are getting easier and easier, but it sometimes depends on the law firm. So we have 34 people now. Harmony B, cases in Los Angeles. There you go. So the issue is, can your son accept service for you? I would argue no, depending on his level of debilitation. His age may be a factor. But you're in just the facts alone, you're going to be fine. This is the way you put that in an affidavit and attach it to whatever it is you're doing to fight back. Harmony B, same. Oh, X. This person sends me hearts and loves and kisses and all this. X, Y, L, S, T, E, P, 4. Extra large step? I don't know what that is. If I miss the date to state a claim in arbitration, can I state my claim in the motion to dismiss? I'm not quite sure what you're saying, because that has many outcomes. Can you repeat that for me, you wonderful person? And thank you. Keep the kisses coming. Joma B, I got my credit card with Central Bank, and Central Trust Bank is suing me. So there's probably a merger. See, Discover and Cap 1 discussion. I use Fargo. To file my answer, if the plaintiff claims that Central Bank and Central Trust Bank are one. If the plaintiff claims, so repeat that question if you don't mind. Thank you. Oh, do I still have a defense? You're saying the plaintiff claims Central Bank and Central Trust Bank. Well, when they say Central Bank, can you tell me in what context? Thank you. Friends from TikTok, is arbitration fair, or do they work for the credit bureaus? Business owners disputed online and they don't fix anything. I am going to be in the minority when I say this. The arbitration doesn't work for anybody. It's based on the word arbitrary, meaning, is that guy gal or guy making a decision an attorney? Is he following court rules or arbitration rules? His own rules. Yeah, it's funded a lot of times by the creditors. I don't like arbitration from the standpoint is, if you are on the hook for this and you have few defenses, but they still have their burden of proof. You stay in court, it's going to take 6 months to a year. Arbitration can have you a judgment against you within months. And they're going to charge you arbitrarily more than you could make a deal if you can show in court, and you can't file a court defense on BS. If you can show by good faith they haven't proved their chain of title or burden of proof, that discussion about assignments and all that stuff, which is great stuff for you, is not discussed in arbitration in the way that is beneficial to you. Act accordingly. Got denied a motion set aside on the default judgment, but never was served and used that as the motion. You have to prove that and you will win it. That's in the proof. So do a motion for reconsideration or do an appeal, assuming you've got a court record that shows definitively that you weren't where they said you were, didn't live there, whatever the basis of your reason to set aside. And the court saw this and looked the other way, and the time limits were respected. So in Michigan, under 2.603, which is how you set aside a default, you have certain times to do that, up to a year in some cases. Also under MCR 2.612C, you have certain reasons. But if you go beyond a year, so you got the judge against you a year and ago or more, you've got to hope and pray that you've got extraordinary reasons why you took that long. So here's what happens in that instance. You get a default and you sleep on it. You get a notice from the tax commission or somebody telling you you got a default, and you go, oh, I'll get to that. We're all busy. If it comes out either on the court record or your admission or a letter or something that the court can look at, that you found out about the default in May 30th of 2024, but you waited several months, you don't win that, because commonsensically, you would act immediately if it wasn't your debt. I'm not saying it is your debt, but the court will look at it through that vein, through that prism. Like, if I was sued on a debt and got a judgment against me, I'd file the next day to set aside. But if you wait, and people do because they're busy, court's going to hold it against you. That's why there's a time limit to overturn a judgment. In Michigan, after a year, you have to go under MCR 2.612F and show extraordinary circumstances. One is, I was in a coma for a year, or I XYZ for a year. I truly didn't realize. I do not live there. You got the wrong guy. And I saw this and thought, well, I'm Brian Parker. I'm not Bryant Parker. I'll just blow it off. And you'd be right. Why should you have to spend any money? But you should. I'll very quickly, when I was a new attorney, after 8 years, I got a really good case. I'd tell you over a beer one time, and I'm going to say this and people laugh at me, but I saved the world with this case. I really did. So I was given all these accommodations, and I became the lawyer of the year, and one of the lawyers of the year in Michigan, after only 8 years of being an attorney. I'm no great shakes. They made me the lawyer of the year in Michigan for this one case. Well, at the time when we had this paper called Lawyers Weekly, and it was all print, that went to every law library in prison, and every prisoner saw me on the front of this huge newspaper for lawyers and law students and paraprofessionals. It's all about lawyers, just like magazines about real estate or Plumbing Central or whatever. And Brian, with a different initial, Parker, was in jail, I think for manslaughter, and saw his name, me, and instantly started practicing law as Brian Parker. And I'd get these calls, where are you? You're supposed to be in court and we're going to sanction you. I go, hey, I don't practice that. I don't have a criminal case. And he kept getting caught. They'd move him to another jail. And then I'd get notice of a court hearing that I didn't ask for. So I go, oh, guess they moved him again. So this went on. And finally, a murder suspect came to him in jail and said, look, I murdered this person, but I hear you're an attorney, quite a famous one. Can you get me out of this? So that Brian Parker said to the murder suspect, sure, tell me all about it and how you did it. And he did, because he felt like he had attorney-client privilege with the Brian Parker in jail. So then Brian Parker, apparently in jail, is quite a scoundrel, but a lot of criminals, went to the prosecutor in his client's case and said, hey, man, I can give you the goods on this guy. I've got it all. He told me everything if you reduce my sentence. I get a call from a judge in a murder prosecution. What are you doing? You're breaking the privilege. We're going to go to the state bar. And I'm like, what are you talking about? So I had to go ballistic and be more than a problem Parker in that situation. They made me come down and be a witness in a murder trial just because I got my ID stolen, obviously. I had to keep a file of all the letters and everything I'd done through all the different courts throughout Michigan, chasing this guy down. Because if I ever got pulled over and they think I'm him, I'm going to jail. I'm going to get messed with. So I kept a file, and I bought a gun, obviously, because I got a family, a young family at the time. So that stuff happens. I'm not sure where I was going with that. Filing a motion to dismiss. There's a way to state my claim against. I'm sorry I did that to you. Oh, I know why. So you can have a judgment against you and you just blew it away and said, it's not me. Well, that's an extraordinary circumstance. The judge's not going to like that, but he's going to see you don't owe the debt. So this lovely person says, yes, I adore you. You're helping calm the anxiety of a lot of these processes for me. It's pronounced Z-Lee-Step. All right. I didn't state a claim because I wasn't well and missed the deadline. So I'm filing motion to dismiss of claim against me. What I want to know, is there a way that I may state my claim against them in my... Yes. There are no rules saying you can't show what they did. If you're asking, can you sue them in a motion to dismiss? No. It's a separate pleading. And one of the first things I learned in law school was a motion is not a pleading. I didn't know what that meant, but a pleading describes a lawsuit. A motion describes what comes after the lawsuit is filed, and you're only asking the court to move or agree with you in some area, motion to compel or something, whereas a pleading is the beginning of a lawsuit, and the motion does not exist without the pleading first. A motion does not produce a pleading, as you are asking, if I'm asking that correctly. In Illinois, if a plaintiff files a standalone motion and then a few days later files the exact same motion, this time with a notice of motion, which event governs the 14th. Okay, so you may be talking about amendment. They may have noticed something wrong, so they refiled it. And generally, amendments are retroactive. So when you amend a pleading, and within the statutory time, or the judge gave you a right to amend your pleading after the statutory time, the new pleading that you amended jumps up in the air and lands on the old pleading, and it disappears. And it's as though you filed retroactively the new pleading originally. I hope that explains things. Can default judgment be voided for lack of evidence of a debt? No. Because you have to first get the judgment set aside. What you're describing is a defense to that action. A judgment is an end of the action and case is done. So set aside the judgment, then that is a defense. Now, can you bring it in your motion to set aside? Sure, throw it in there. If it builds on the real reason why you should get that judgment set aside. Eva Tompkins, that's super cool that you got Lawyer of the Year. I was 38, and that year I traveled throughout the nation. They actually pulled me in front of Congress, and John McCain at the time and Fritz Hollings started fighting. John McCain didn't like me. And Fritz Hollings said, Mr. Parker, and he had a southern drawl. He's from South Carolina. I'm sitting in my $200 suit going, how did I get here? I'm in front of Congress, and John McCain is yelling at me. And I understood him because he was in a cage for 5.5 years with people prodding and knifing and beating him up. And he said, I ain't giving you what you want. So he looks at lawyers, especially personal injury attorneys. Sorry, you're complaining about your back? Well, by the way, backs? Yeah, but he doesn't look at it like that. He goes, I got a broken arm. I can't lift my arms. I have to have someone, so he's ornery. So he was looking at me as just the beginning. At the time, the tobacco settlement had just settled for billions. And now all the lawyers saw my lawsuit that I'd filed. It was the only one of its kind. And we're all getting ready. So McCain was passing a law that protected businesses. And Fritz is like, he took money from the Trial Lawyers Association. So they're both yelling at each other. I got so pissed. I can't tell you what I did to John McCain, but I went down the hallway and found his office. Back then, it was before 911, 9/11. So you could basically walk around. I'm not going to tell you what happened after that. So I was pissed. So there's a lot of people now. I got to go up. That is crazy. Oh my. Help me understand that I've been served and I'm pursuing the route of filing bankruptcy. Do I need to submit the answer? When you file a lawsuit, when you file bankruptcy, officially, everything stops. It's called, there's a stay. I'm not a bankruptcy attorney. You can neither be sued or sue. Anything coming your way is put in a stay. Judges love that and hate it. They love it because it's one less case they have to deal with, but the file just sits there. So you saw that a lot in the real estate financial crisis. Everybody started filing bank. It stayed a lot of stuff. So that's the answer to that question. So no, you don't answer. Once officially you have a piece of paper that says it's been filed, that's up to your bankruptcy attorney. He or she will tell you what to do. She'll notify all the creditors. It's gone. So requested debt verification from collection agency. They sent bill of sale, borrow agreement, certificate of sale of accounts from Richard. What should I do next? I'm following up saying you didn't answer my validation request. Can you show me my debt inside these things, not a bill of sale that isn't an assignment, or your assignment that doesn't say my name or account number? You might not stop anything, but it will be on record as the beginning, letting them know you're not to be messed with. And if there's a lawsuit after that, that's the basis of your counterclaim. They just stuck their foot in it. And at the end of the day, they still got to prove they own the debt, which they can't because they told you early because you were smart enough to do the validation. So that's like a problem Parker garbage time move. In Iowa, I need to respond. I have 15 days left. Getting sued for Midland for old credit card for $1,200. What do I do now? Dude, I'm going to repeat this. I'm in Iowa. I need to, sorry if you're of the female persuasion and I called you dude, but what I'm saying, I'm exclaiming, and you'll see why. I have 15 days left. That's good. Getting sued from Midland for old credit debt for $1,200. Do not hire an attorney for that. What do I now do with your monthly services? From the hilltops and the high heavens, Parker GPT is everything. It does all the work for you. You got to take a look and make sure nothing's perfect, but if it does 90% of the work for you and you just got to do 10%, no one else is giving you that. You've apparently have not hired me, but gone on the monthly service. So I'm not telling you to spend $149 on me. You're already there. I've got nothing to gain from helping you. And I'm telling you, Parker GPT is phenomenal. And you've got the prompt. So you go, hey, you take your lawsuit, you feed it in, you upload it, and you go, can you give me an answer to this? But then press the rocket ship. And it goes, you big dummy, don't ask it like that. No, it doesn't do that. It says, how do I answer with affirmative defenses, following up? And it gives you a better way of asking. Why? Because we want to give you a better response. Because what happens on any chat GPT, Parker GPT, if you don't use the rocket prompt, it's all the same stuff. It's question and answer time. It's not perfect. So you go to chat GPT and go, hey, what's a good shampoo to use? And they'll go, water. You go, no. You got that wrong. Shampoo, with soap. Soap. No. The kind that doesn't hurt your eyes. So you have to keep fixing your prompt. So when you do a search into Google, that's a search. Well, for some reason, I do know this. When you put your search into the prompt box, that's called a prompt. you're, if you will, prompting the LLM to give you an answer. The better that questioner is, the better the response. You don't have to go through, no, I meant this, I meant this, I meant this. You eventually talk the ChatGPT giving you everything you need. You can speed that process up by pressing the rocket ship, and it will give you the question to ask. And you go, great, click. Now you get this great response. I hope that makes sense. You've already signed up. I'm not selling you on my service. I'd love everybody to be a member, because this freaking Parker GPT is me. We've had to do some things to it. It's getting a little handsy. I don't know if you know, ladies, what handsy means, but we've tuned it to love you and to really want to do the best for you. And some people have actually fallen in love with it and Natalie, and we've gotten some strange messages from that situation. So it really wants to be healthy and happy and make you answer all the stuff that you want and need. Just please don't send me candy. So hope that makes sense. You answered perfectly. X-List Step 4 says, I appreciate you and don't apologize for anything. You're helping us. Much strength, peace, and return all the good to you. Heart, heart, heart. I'm blushing. Oh my. So Harmony B, I served judge with a statement to disqualify judge. Wow. Ruled on his own challenge. Well, it's called generally it's called a recuse. You're asking a judge to recuse herself. And then you cite the reasons. And her response is going to be, nah, I'm going to be fair against my brother that's litigating against you. Or she's not going to say that. But you have a right to do that. If your reason is good enough, I'm going to tell you something. I'm a bit of a jerk when I'm representing someone because they're me, but I can't be a bigger problem as some non-represented people can be. And debt collector attorneys, to a man and woman, they will tell you when we talk. Oh yeah, I'm going against a non-represented. This guy is crazy. This guy. They always say the person that's not represented attorneys are crazy. I guess crazy people don't hire attorneys. And it turns out that the person's doing a pretty good job. That's how crazy they are. And the debt collector fears getting beaten. And the judge gives the pro se defendant generally leeway. The debt collector just wants to walk in, abuse him like any victim. And now it's being stopped by a very competent person. That's the reason I created this website, was I kept meeting these people that were really smart and handling things. And that was one reason. And maybe that's what they need to finish the case. So this is for you, educated people. And it scares the hell out of the other side. You'll get that case settled. But don't be too good of an attorney in front of the judge, because the judge will start treating you like an attorney as opposed to the leeway. And so I always tell people that I talked to someone today, preface everything you do like, I'm not an attorney, and this is hard for me, but blah, 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 and then make this great argument and make this say, I just got to say, this just came to my head. I haven't said this before, and I'll go back to questions. What time is it? All right. I'm giving you extra time because I messed you around at the beginning. Please, if you get a chance, when you're in a hearing with the other side, don't refer to them as the company, their name, their position, whatever. Please keep saying the debt collector, no matter what it is. Well, the debt collector, because it's like, no offense, used car salesman or timeshare salesman or whatever bad thing you think is bad. It's debt collector. Like it or not, we all have impressions of certain things that are said. So if you keep calling them debt collectors, the judge is going to, that's a debt collector. He's not going to say Miss Smith, because it goes the other way too, because she has probably appeared in front of the court before, and he may know, oh, I'm Miss Smith. How are those kids? You don't need that stuff. So just keep referring to them as debt collector, even things out of it. Used all the assets you have. So I serve judge. That's good. I'd like to know how that turns out. If an original creditor is suing, say Capital One, say Capital One. If wanting to settle, I've had a long day, so if I say weird stuff, sorry. If wanting to settle in lieu of dragging out a court for weeks, what the alleged debt owed, would you think they'd, oh, I can't do that. But you know who can? There's a couple of videos on how to settle pre-litigation. And I swear to you, I know clients that have settled cases using Parker GPT. It takes all my videos and all those documents. Sorry to keep repeating myself, but I got to make a point, and puts it into Parker GPT. So you're talking to my video or you're talking to me. Thank you for what you're doing with, shoot. After the court papers are issued. Thank you for what you're doing with your website. I wish more consumers would wake up. Okay, that's very nice. Pug Porrent, I love that. Glock, funny. Joma B, I filed a discover with set of interrogatories request for production document request submissions 8-6 until no answer. When you say hearing, is it a hearing? So, okay, so in most jurisdictions, if you file a request to admit and they don't answer within 28 days or 30, it's usually 20 or 30, those are automatically admitted. So whatever you said for them to admit, you no longer have to prove. So if one of your, and it's done the other way, but if one of your requests to admit says, admit that I don't owe this debt, and it's the 29th day, it's automatically admitted. Now they can come and go, Your Honor, I was having a baby that day, so I wasn't able to answer. But then you could say, oh, so you're having a baby the first, the second day, the third day, the fourth day, the fifth day, the sixth day, the seventh day, keep going. I mean, they're going to fight that. But you put yourself in such a strong bargaining position. If that, when a request to admit come from the other side, that's the first thing I do is answer those. I don't want those hanging out there because they're dangerous if they don't get answered. So you are in the driver's seat. There's a very old book by James Ferber, and it's there's an expression from the catbird seat, and you are in the catbird seat if you have a request to admit that they've missed the 28 or the 30 days. I'm mad at myself right now because it's a big movie with Ben Stiller in it. Shoot, I'm going to look it up. Sorry to waste your time. This is how my brain operates. Sorry. Nope, that's not it. You got it wrong. Sorry. Yeah, you're watching this. Great TV, yeah? Okay. Yeah, it's the catbird seat. Interesting. There it is. The Secret Life of Walter Mitty. So there's an expression in The Secret Life of Walter Mitty. Oh, so you're in the catbird seat. I have no idea what that is. But that meant you're the winner. You're in charge. You have it all right now. You can look around and I'll take that. I'll take that. I'm going to win that. My friend. Oh, I hope I didn't. I hope I didn't. If I lost you, please. Can you guys all hear? You're in the catbird seat. Pug Parent says, I'm eating dinner and being sued. I never had so much fun. This is good TV. Can you guys hear me? I don't know if I just did it again. Yes, you hear you loud and clear. Thank you. I'm an idiot. I'm just at a long days, just grind too. In the law, there's very few great moments, so you latch onto them. There's a lot of understand, sometimes I've got 200 cases in my head and I take them to bed, and I argue them. As I've gotten older, I've lost the ability to say, "Could you please stop? I need to sleep." I actually one time had a case say, "No, you're gonna deal with this. I swear to you." I had to take a one I take one pill now to straighten my ass out, but it actually is pretty cool. So, um I'm not liking what I'm seeing on the screen, not my face, meaning there's a delay. Are you guys able to hear me properly before I get back to this? Can you hear me okay? I don't like what I'm seeing. I hear you fine. Okay, good. Okay, so I love the thing. I'm eating dinner watching this. Um, I'm really behind now. Capital One, Glock, lots of hearts and kisses. Work well. Remember to ask for state-specific responses. Have you incorporated case law? Oh, yeah. So I just said at the beginning, I signed a contract with a very nice group of people, nonprofit, to put over 1 million cases into Parker GPT. I am not going to sit here and tell you I know what the hell I'm doing. The developer does it all, and it's like they're the new car mechanics. They tell you the breather is broken. You go, okay, replace the breather. They so far Parker GPT is wildly beyond my expectation. I found the right developer. Um, so the answer is yeah. Can we use it similar to Westlaw and Lexus? Please do, because it's free. I mean, you're paying the 149 for the membership, but it's free. Every month you pay for a Lexus Nexus beyond whatever else you pay for. I'm gonna give it to you for embedded. So if you've paid 149 for this, all the stuff we got, I'm gonna give you the stuff, and I'm not gonna charge extra. I hope that excites you. I use Parker GPT more. I don't like ChatGPT, and I want to, but it's in your lane. It's in the defense lane, so we can do nothing better than do the best we can for you, as opposed to ChatGPT, which is scattered and comes up with different answers. And again, we want to avoid the hallucination. I don't want to miss anybody. Have you incorporated? I have an $11 million cross. Cut me in. I have $11 million cross complaint that the judge granted here at trial. Wow! Why can't I find an attorney to get this case over the goal line? Because of what I just did. Uh, Kronos iCore. Have you incorporated case already? Yes. The AI works really well. Tip, remember to ask the state. Oh, okay, sorry, Pug. Yeah, but get back to what I said and what Pug said. Remember to ask for state-specific responses, but use the rocket ship too. I hope that helps. Harmony B, judge is a CPA and a plaintiff is a CPA. Opposing does not oppose my motion, and judge denies them anyway. All right. How to stop that if somebody else fears that's gonna happen. If the other side didn't oppose, then you go to the other side with a stipulation for what it was your motion was seeking, and don't put it in front of a judge. Judges, you try to keep everything out of the judge, unless it's something you need the judge for. But it's better to settle cases with the parties, but keep it away from the judge. That's one reason. Or the other side says, "I agree with everything," you don't go to court way. You agree to stipulate to the thing you're seeking from the motion, and you file that with the court, showing that you both sides agreed, and then they just generally will sign here, done. Hello, sir. You're still taking clients with federal FCA. FDCPA case. I'm too busy doing this, so I only take really quick cases or ones that really turn me on. That's not turning me on right now. I hope you don't I've always been handling the little guy defense. Right now, I just try to do debt buyers. I just love that stuff. But I wanna do this 100%. But still taking cases on the side. But it's 32 years. Look at me. I'm only 40 years old. Look at me. So Ken, let me alone. I asked a collect where they got my info. They wrote to say that they've closed the collection account with the credit. Send them documentation. I want to sue them for calls and deception. If they have broken the law, you can, and that would be a federal lawsuit, but you must have damages to have standing in federal court. And they're very serious about that. A lot of the Trump nominees have gone in pro-business, and they've started to attack consumer statutes like the DCPA, the FCRA. In fact, one of the FCRA cases, Ramirez versus TransUnion, just upped the ante. You have to show extreme damages to have standing. So always have damages when you're filing in federal court. You can drop down and file the same case in state court. Here's a fun thing I like to do. So I stop filing in federal mostly unless I've got good damages. I drop down to state court, file the same FDCPA case, and sometimes, especially in Florida, the FDCPA case is much better than the FDCPA case. I sue under both to avoid the Article 3 standing defense of the other side killing my case. I can't bring that in a lot of states because it's not a federal, there's no Article 3 in the state generally. So the guy that I'm suing, the debt collector, will remove the case back to federal because he knows he gets a better shake and then files a motion to dismiss under Article 3 standing. We're getting on standing. I kicked their ass on that because I didn't sue in federal court. I sued in state court. They brought it back. I've had this happen. And the federal guy, the defense attorney starts motions to dismiss based on standing. And I look at the judge and go, why I didn't file here? I didn't ask to be. And you win sanctions and everything. I'm just telling you something separate from what you asked to kind of show you about standing. Have damages if you're going to do a federal case as you want to do. And make sure what they did is deceptive and obviously violative. You're gonna go into federal court and give damages. There's no amendment filed, no other paperwork other than a motion, followed by a motion with notice of motion to deem response timely filed or leave. I don't know. It's too it's weird there. I don't know. You'd have to explain it really well, Ken. In the case I'm working on, I filed answers with new matter. They never answered. Filed answers with new matter. So I filed a motion to deem new matter admitted. If you're talking request to omits, then I agree. Most of them for summary judgment, based on those requests to omit, I definitely agree. Leave me alone, says I mean deceptive practice, harassment with 22 calls. This specific, okay, so for that, go to the CFPB's new rule changes to the FDCPA dated November 30th, 2021. They changed the rules. And I believe they said only 8 calls a day or something like that. So you then attach the CPF change, the new order to your lawsuit, and they violated a federal ruling of governing agency that's governing, that's designed and created to make the rules of the FTP. So 22 calls is 14 calls more than allowed, blah, blah, blah. So check those new. They said they stopped calling, but did you file a cease and desist? That will help. Pug Parent. Parker GPT said send them a letter for them to pay me 75K. Rock and roll, but be aware. You remember I talked about how it falls in love? Wants to please you. So your prompt, it may just say to itself, "Oh yeah, your case is great, and it's the shittiest case going. So be careful. Just check your facts and law before you do something like that." It's again, it says right. I'm not being a jerk disclaimer guy. It says right on your result. Check this stuff. It's not perfect. That's a great expression. Don't throw things at me. I like the expression. Obama was asked because he screwed up a little bit, and they said, "Hey, you promised this, and yet we're only getting this." Let's say it's for the insurance, which turned out to be pretty good for folks. And Obama said, quoting somebody else, "Don't throw away the very good for the sake of the perfect." But his point was, okay, so it's not perfect, but it's pretty good, right? Don't deny it or disavow it because it's not perfect. I would argue that Morgan GPT, I'm working my ass off to get it so great, perfect training. I'm trying to get the P to mean perfect, but don't throw away the very good, okay? Just check your sources, check what it says in the result. I am working hard for you. I am spending money, put a million decisions, oral arguments, state court legal opinions. I'm reading this, 470 jurisdictions in that thing for you. It's gonna get better. It's already great. It's already very good. So I have another little I've discovered the accountant who is suing me was laundering money through my Chase VP branch man. Looks like money laundering when she looked at Doc Jody Rickman's witness statement. I'm glad for you, but I don't want to get into that. If you don't mind, it's too much. I have another letter from Blitten Gaines. They gave me until September 26th to apply. It says you had a Capital One. Is this a debt collector or am I getting sued by Capital? I don't know. You have to repeat that. Harmony B, I'm thankful for you this, by the way. E-gas IRS. I'm reading elements of international law. All contracts are maritime. How can he not know this? I am not going to lie to you and say I know what that's about. Pug parent. I'm eating dinner, getting sued. Never had too much fun. It's good TV. Thank you very much. Henry Wooten, Elements of International Law. All right, 1866. Yeah, he is loud and clear. Harmony B, ha ha ha. Thank you. Pug Paren, yes, I hear you. Oh boy, am I behind? Sorry. Revelation 13:15. CB watch. Yes, I hear you fine. Glock, yes, sir. Can you hear Wisconsin? Can hear you. Thank you. Marja, yes, I hear you. Bad Bud Badger Troll account 172. Never dropped. Thank you. I thought I pressed the screwed up. Mark Evans, yes. Bad Badger. All good. 11 million because the account closing to lose 74 a year business. Whatever you use to go get him. Hi, Brian and Senko, your star student from Ohio. I'm going fast now. I apologize. I contact opposing. Hello. I contact opposing Harmony B says, they say, I'm thinking of filing a motion. Will you oppose? And if he says no, get an agreement in writing. Thinking of filing a motion to yes, get a stipulated agreement that the judge will sign up. Cheryl Sinkle says I'm breaking up. Hopefully not with her. So Harmony B, the case should have been filed. All right, Harmony, we're going to move on to somebody else. Ma Jones, an accounting claim while the case is still active. Can I ask for damages? You can always amend if it's within a certain early time. You can automatically amend depending on your state rule, but file your motion to your counterclaim. Attached to it, the proposed amendment pleading that you want to have be the new pleading, so the court can make its decision. If it's too far from your original filing, the court will say probably yes. If it's close, it'll say, just go ahead and add that. You may be able to get the other side. So don't look for that. But if you do it in a pretrial, sometimes the pretrial will go to the other side. You're not opposed to making this case move quicker and just let me do this, right, counsel? So it just depends on your, what did they, my ex used to say about my kids? Pick your battles. So, John Briggs, hey, John, what do you do when debt collectors validate and sell it to another debt collector? Does it go on and on? No. Great question. So here's a trick I use. In my validation letter, I ask for validation. And I say, if you plan on sending this to somebody else, please tell them that I dispute this debt. There's case law that says once a debt collector knows that it's disputed, they have to tell the new debt collector it's disputed. Or the old debt collector is subject to litigation. Think about it. The new debt collector does not want your debt disputed, or they don't want to buy it if it's disputed. It's already cracked. So there is a possibility that the new debt buyer or collector could sue for contribution the old one once it finds that information out. So always put in your letter, you dispute this debt, please tell any other collector you pass it on. Pretty cool. Now, what you asked, the new guy has to give you your new 30-day rules to validate each time the new collector shows. I think what you're asking is this just gonna go on and on? How do I stop this? I can stop this. If you don't owe the debt or don't care is the best way to put it, file only a cease and desist. Say, I refuse to pay, cease and desist, see my last video, instead of a validation, because they can still keep contact with you once they quote unquote validate. The cease and desist is forever. And if you have to, send that to anybody else who shows up. But make sure you say in your letter, I dispute. Pub parent, no, poor rent. No expectations on the settlement, just having fun with Crown asset. You know, a funny thing, I do consultations. People have 15 minutes or 30 minutes, or they did a full hour. I always give them more. No, don't go hire me because you want more. Well, go ahead. I'm gonna give you more. So, um, lately, especially with couples that call me, couples consultation, I'll figure out that we can settle the case very easily, less based on what they told me and how hard they're working. And I go, just go tell them you want to settle for 2 and they'll take 25. And lately, they've all been saying the same thing. Nah, we're not doing that. I go, what are you crazy? You're gonna go through litigation. Save $4,000. They go, we're having too much fun. So I don't know what they're teaching you. A lot of people are having too much. So let me alone says, does it turn you on to sue a bank that withdrew 30K from someone's account 6 years after charge-off? The statute of limitations is to collect the debt in 4 years, or could I at least book a consult? You're unfortunately wrong, because the statute of limitations isn't on a judgment. There's 7 years for something to remain on a credit report. Like you said, you can't sue on a debt after 4 years. You can't collect. You can keep collecting forever, just send them a cease and desist. But once a judgment, which is the premise and foundation of them taking your money, occurs, they've got 10 years in some states, 20 years if you ask for another 10 years in Michigan to keep doing that. So the statute of limitations doesn't apply in short. Wayne DeMardo, message retracted, pug parent, message retracted. Harmony B, validate the debt or verify the debt. Most of the same thing, just put the same. both words in the validation. Sorry, portfolio recovery has an active consent order against them. Midland had several. Yeah. Yes, attach it. Judges, in a way, will thank you if they're on the fence about which way they go. And by the way, the consent order is a federal, two things, is a federal order that trumps state. You say, Judge, we got to follow federal law. That's kind of butchering what really is not really precedent, but it is federal. And number two, take a look at the consent order at the bottom of it. It'll be signed by CPFB. It'll be signed by PRA and or Midland. Why? Because it's a consent order. Just like when you get a consent order, you both agree to this. So they are signing not to do the things that they're doing. They signed on the line that it started. See Glengarry, Glen. So that's how you double dip them with that consent order. Judge, it's a federal order, they're ignoring, and you can attach them to a federal lawsuit. And B, Your Honor, that's a PRA signature promising not to do it. They violated their own agreement. So that's a double dip on their ass. The CFPB versus PRA, I did a video on it. It's from 2023, where they got fined 24 million and agreed to stop doing what they do every day. Let me alone. There was no judgment. I have a checking account with the bank, and they went into my bank, took over 30, caused you more than anxiety. Then you must send them a letter saying, please explain in detail why you did this. And if they don't, that letter unanswered or answered wrong is then part of your. So in the little history in the 60s, Kennedy puts missiles in Turkey. Khrushchev puts missiles in Cuba. We go to war. We almost go to nuclear war. We force Khrushchev to remove his missiles from Cuba. That's 1963 crisis. But we've got missiles in that area still. So Khrushchev, the president, takes his shoe off and bangs on his table. I think it's you, and he says, "You think we lost? We believe you take one step backward, the shoe, two steps forward. Today we take two steps forward. Just watch." And that's how you saw them build up the military fight before Reagan. And that is what I think of when I tell you to send a letter out. Don't sue right away. Take one step backwards. And if they send you a letter that's full of baloney, or they realize that it's wrong, or they don't respond, you take two steps forward by using their own letter, use their own document against them as they did today, among other things. But you can't just take stuff. I would talk to their garnishment department. But keep a paper trail registered by mail. Don't be using the phone and going. I talked to Cindy down in garnishment. She said I'm totally right about this. Who's gonna care? Send a letter to Cindy saying, "You remember we had that conversation and you said I was right on May 5th, 2025, and you said blah, blah, blah." That memorializes what was said, and that's keeping everything right. Or everything you want to know or do, send a letter, certified return request that they have to sign for it. Is the best way to handle it. It is now 6:58. I've had it. It's Friday, and I want a sipping bourbon. I very much appreciate you all being here. I don't see any more questions. Thank you. You probably already started the bourbon without me. Even the guys 3 hours behind. So I'm going to wish you adieu. I gave you 2 hours. Now listen to it. I gave you an hour for Have a great evening, you all. Thank you. I love you guys. This was good, and I plan on doing more soon. But check out Parker GPT. We're filling that with a million unplugging. cases. 149, it depending on what you're spending on 149, I've got so much in there, I could be charging a million for it. I'm kidding. This is what you need. Don't pay an attorney. Go for a month. Even if you just do it for a month, you can get so much out of this. Whereas an attorney, I charge $500 an hour. I've been doing this 30 years, and it's hardly anybody doing this. And I charge more. But for 149, you can get good, and I hope you understand. I gotta charge something to keep this thing going. I used to do all of this for free on my collection stuff website. I had a section called Podcast Plus, and I gave everything away, everything. Got to be hard work stocking and doing my real job. And I said, if I'm gonna do this, I should at least get paid. So I just started charging. I opened this site and I charged $49 for a lifetime membership. And there is a gentleman, I think he's listening today, that signed up with me for $49. Today he has all that you have for $49 a month. I'm looking at my paperwork now because I want to make sure that great guy did answer his question. His question is the following. LVNV funding is suing my client in state court for $1,800. The complaint has a letter showing banks sold it to Resurgent, not LVNV. This may have been asked. It was a template completion error to research. It was asked. Give my client a hard time because the client is showing that there's no proof. And yet the judge is going, yeah, but you owe it, right? Essentially, your AI prepared a draft complaint. Should we file it in federal court? Is that the way to go? No, unless you have provable damage caused by the person you're suing. And an affidavit, I had to do this as a result of a false lawsuit. The video I'm dropping tomorrow, hopefully early, will address um, the very genesis of most of the federal cases that I file, which are my client being sued based upon bullshit, chain of title, chain of assignments. That's a common thing. 90% of the cases end up in dismissal. So they don't bring the right side. No. If my client is damaged because of that, a good example is that they don't have proof, but they put it on his credit anyway. I've done videos about that. That's a damage. It cost him a ton of money because they sued improperly. They sued him in the wrong district he didn't live in. So he had to go up there, do all this work and miss work. Those are damages. That case actually is on my website. I think it's called Articles of Standing with all the federal motion, complaint you need to file. But don't do it. I would wait until you win that lawsuit. That's what I used to do back in the day is I'd file an answer and file a counterclaim against the debt buyer. Then I'd file a federal case against the debt collector law firm. So they finally said, "Oh, it's gonna stop." Like, right now, I'm doing a lot of cases where there's fintech. I'm suing the trust now and Upstart Network Inc., which is usually Cross River, in a third-party action just to cause them greater problems. They are the real problem causes. So that's a time when that's necessary. I did it in a third-party claim. So I would do what you're talking about, either a counterclaim or a third party. If you win the case, now you've got a judgment that says, hey, they filed a lawsuit that the court down there found to be bullshit. Case, the video you can see tomorrow, that's based on the exact same scenario. However, the person waited until a year after the case was filed. The federal district court threw that case out because they violated the 1-year statute of limitations. It was too late. So This person appealed to the Circuit Court in Washington, Ninth Circuit, and won because even though it did pass the statute of limitations, it couldn't file the CPA case during the litigation. The defendant that you learn about tomorrow did some really violative things. So the court said the statute of limitations didn't start when he was served. It started when this guy did his bad stuff. You can sue on that, but you can't sue on stuff that was not inside the year statute of limitations that started with the middle of with the past. It'll be clear when you watch the video. So I say that to you, my good friend, and all of the guy that brought this. Uh, don't wait to bring your federal lawsuit while you're waiting for the state law to finish. You want that to be supportive of your federal lawsuit. You can file it if you see the statute of limitations on whatever thing they did is about to end. You can always amend your federal lawsuit if you win the state law case. And that'll all be clear in the case and the video tomorrow. And that is it. Oh, I approve Upstart. I'm gonna go serving a loan after it's sold by them, Crown Asset. That's a great case. Look at the footage. All right. Goodbye, all. And I think that last case, the LVNV funding, do a motion to dismiss. We started this video with alternative motion for more definite statement. Make the judge have to make a real decision. Good luck, you all. Thank you. Pug Porrent. I don't know who you are, but I love that name. It was great talking with you. It was great talking to everybody. And thank you for the hearts and kisses, even from the girls. And we'll coming at you real soon. The new video drops tomorrow. That's it. All right, I need a bourbon. Which there's no connection to either one of those. I just need a bourbon. Okay. Thank you. I don't know how to get out of this now, so now I'm gonna have to try and how do I get out of this? In stream. Bye, guys.